Are we ready? Okay, so we go straight on. And can I ask each of our two witnesses to identify themselves for the record, please?
I'm Professor Meg Russell, Director of the Constitution Unit at University College London.
I'm Jonathan Sumption. I retired from the Supreme Court last December. I'm currently a visiting fellow of All Souls College, Oxford.
Well, it's a great pleasure to have you both. And can I just make an initial observation before we come to our first scheduled question, which is, what is striking is that the judgment rests on a lot of case law, and particularly the case law around judicial review, which itself is, to some extent, invented law. It is not based on statutes. And even the case of proclamations is used in a way which, in a reverse way, this is because the case of proclamations was based on the prerogative not overturning statute, and there is no statute to rest upon in this judgment. So we've come a long way. To what extent do you think the judiciary is developing different juridical techniques, different understandings of its role, so that we actually have a different judiciary from what we had, say, before the 1960s and the invention of judicial review?
Well, all common law is invented law in the sense in which you described it, sir. But the function of developing the common law has been exercised by the courts ever since the 16th century and arguably earlier. The short answer to your question, are judges animated by different attitudes now than before the 60s, is yes, they are. They have exercised a much more intrusive role over the control of government business. They have done that essentially because of the growing power of governments and the growing importance, therefore, given the range of matters that governments deal with, of having some reserve system of control over what they do.
Professor Russell?
Well, I think by way of disclaimer at the start, I should probably point out that I am the only non-lawyer that you are seeing today. I am not a court watcher, although I did find myself glued to sessions of the Supreme Court hearing in this case. I'm a Parliament watcher, and I think that's probably why I'm here. But I think it's well known that there have been a series of changes which affect the role of the judiciary in our system, things like the Human Rights Act, etc. And we might come on to Jonathan Sumption's claims in his Reith lectures about the rise of law and the decline of politics. And I think that we've already had something of an interesting conversation about why that has happened. And I think it's not necessarily to do with judicial overreach. Partly it's to do with politicians actually stepping into the background on difficult decisions. And partly it's the behaviour of civil society groups as well, who increasingly have taken to using the courts in order to get policy change that they're not succeeding in getting through the political process. So I don't think there's necessarily fault here, but the ground is clearly shifting.
I'm not suggesting there's any fault. I'm merely inviting an observation. Eleanor Smith.
Thank you. What do you think is a proper purpose or purposes for which prorogation can be used?
Well, we heard this already to some extent on the previous panel. The typical prorogation is a few days long, and it provides a dividing point between one session of Parliament and the next, or it provides a bit of breathing space before the dissolution for a general election. So that wasn't mentioned, I think, in the previous panel, but there are frequently a short prorogation before the dissolution, not least to allow the timing to work out given the statutory period from dissolution to an election, to make sure that the election happens on a Thursday. So those are the normal and perfectly proper uses of prorogation. We know it's been well covered that there have been various uses of prorogation that could be seen as being more political. One of the ones which interests me is the case in 1948, when there was a prorogation in order to bring on a short session in order to get a bill through that the House of Lords had been resisting. And as somebody who studied the House of Lords. That's of interest to me, not least because the bill in question was the Parliament Bill, which became the 1949 Parliament Act. People have argued that that was a political use of prorogation, but I think, and it clearly was, but I think there is a big difference between that and some of the other cases that we've been discussing earlier today, because that was actually a prorogation to facilitate what the House of Commons wanted to do, because the House of Commons had passed the Act and it was the House of Lords that was slowing it down. So I think there's a distinction between cases where prorogation, and I think the Supreme Court made this distinction, where prorogation is to facilitate Parliament going about its ordinary business, and prorogation which is perhaps going to stymie the business of Parliament.
I don't think, with respect, that the question that you've posed is capable of a definitive answer. It is easier to identify some things that are clearly outside the legitimate purposes of a prorogation. I am a strong believer in the value of non-legal conventions in our public life, and I am sceptical of the value of judicial interventions, although I wholeheartedly approve of the most recent decision of the Supreme Court. The essential problem is that the Crown has enormous constitutional powers which are exercisable by ministers. The basis of that is that ministers command the confidence of the House of Commons, so the use of those powers by ministers of a minority government to suppress parliamentary criticism is a very serious abuse of our constitution. Parliament is an instrument of government in the sense that is not true of other non-Westminster style constitutions. The executive is part of Parliament. The House of Commons exists to criticise government, but also to support it or else change it for another government which it can support. Obstruction of criticism or obstruction of a motion of no confidence, in my view, seriously distorts the balance of our constitution.
I might add, in agreement with some of the things that were said on the previous panel, there are, of course, questions as to whether prorogation is necessary at all. It is part of our system, but we could move to a system of simply having 5-year sessions between elections with recesses each year. There's not necessarily a need to prorogue, and this has been debated in our system from time to time. It would make potentially the passage of legislation much easier if you didn't have what Robin Cook, when he was leader of the House of Commons, used to refer to as the sessional cut-off that led to, as he used to say, a tidal wave of legislation arriving at the beginning of the session and then a rush to get it all through at the end of the session. We've obviously got carryover now, which does away with that a bit. There are ways in which we could rethink the whole system to make the flow of legislation easier across the whole length of a parliament, but that would have some significant implications. One of the biggest complications, ironically, would be with respect to the Parliament Act that I referred to before, being pushed through in 1948-49, because the Parliament Act, the powers of the House of Lords to delay, are based on a bill having been passed in 2 successive sessions. If you got rid of sessions, then you'd have to do something else. You'd have to rewrite bits of the Parliament Act to constrain the powers of the House of Lords, unless you wanted them to have a power of 5 years of delay. But it's interesting that, for example, the Scottish Parliament just sits in 1 session between elections. It doesn't use this process that we do, and it's been referred to that it's not universal overseas either. So we could look at the whole thing.
So what do you think of the implications of the Supreme Court ruling for the continued use of power to prorogue Parliament? I mean, you've just said. And has the judgment clarified the existing rules, or do we need to legislate or some changes which you've asked for, which you were just talking about in practice?
I think on the first part of that I would defer to Lord Sumption. But I mean, it seems to me that it is now clear that there are some constraints on the power of prorogation, but it's not clear where the limits are. We could keep going back and forth, in a legal process and trying to work out where the limits are. My preferred approach would be to do something simpler and cleaner and say that, like the power to dissolve for a general election or the power to adjourn for a recess, you give, assuming that you want to keep prorogation at all, you give the decision whether to prorogue to Parliament. It might be a proposal from government, but it would need parliamentary approval. Or alternatively, I thought the suggestion from Professor Twomey was interesting, that the executive retains the power to prorogue, but that Parliament can petition the Speaker to be unprorogued. There would be an interesting parallel there with recall from recess, because the inability of Parliament to bring itself back from recess has been controversial various times over recent years, and one of the ideas has been that MPs should be able to petition the Speaker to get a recall from recess. So I think if you were doing it for prorogation, you want to look at recess as well. But rather than arguing over the boundaries of it, I think the easiest thing to do is to give the ultimate decision to Parliament itself.
And this could be done procedurally, not necessarily legislatively.
No.
Well,
Go ahead.
Well, in answer to that last point, I don't think it can be done procedurally, because the royal prerogative is a question of law, and the law would have to be changed to abolish it effectively. If the law is to be changed, I think that has to be done by statute. The simplest and cleanest way to do it, and I entirely agree with Professor Russell about this, would be to say that the prorogation requires a resolution of the House of Commons. But I mean, I think there are problems about the current state of the law post the Supreme Court, and you've essentially touched on them. There are two parts of the Supreme Court's reasoning. One of them effectively says, this is not their language, but it's my summary, that it is intolerable that a government can disregard the conventions and simply leave a void in which governments are subject to no relevant control at all, apart from political control, which in a situation like the one we're in now would probably come too late. But there is a second aspect of this judgment which is much more problematical, namely the test which they have laid down for deciding when Parliament can be prorogued and when it can't. The test is that there must be a reasonable justification for doing it. Now, the Supreme Court didn't have to decide whether there was one in this case, because the Prime Minister didn't put forward a justification. I think that was a serious misjudgment. But if ever the government does put forward a justification for reasons other than ordinary business management, the criteria for deciding whether that justification is reasonable will almost invariably be political. Suppose that the Prime Minister had said, I cannot be expected to negotiate with the EU with all this noise going on in the background undermining my negotiating position. Now, people might or might not have agreed with that, but what is absolutely clear is that the only criteria by which you could decide whether that was a good enough reason would be political. There are no legal criteria for deciding what is a sufficiently good political reason justifying closing down Parliament. And that is why it seems to me very important that that before we get another case of this kind, the decision should be handed back to Parliament in the form of a statutory requirement that there should be a notice. Now, although the Supreme Court said the circumstances will never arise again, I think one's got to treat that with some caution. First of all, what is unexpected almost always does happen. Even if you don't know which unexpected event is going to happen, something unexpected is going to happen. Secondly, there is a long history, not in this country on the whole, but in Australia and in Canada, of political prorogations. I think the consensus would be that the successive prorogations of the Canadian Parliament, in particular the prorogation by the Harper government in 2008, when it lost its majority as a result of the departure of one member of its coalition, I think most people would agree that that was an abuse, and that probably the Governor-General ought not to have agreed to it. But it does seem to me that we have a system in which the criteria, whether you agree with it or not, must be a matter for Parliament itself. You can't leave it entirely to the executive. I think it's undesirable in the interests of the court and the constitutional integrity of our system that it should be decided by judges. It's got to be decided by Parliament.
But what do you say to the argument that Parliament did decide it by default, by failing to express an opinion on the matter, failing to remove the government because they didn't want prorogation? I mean, the implication, if you leave a government in office with confidence, it has these powers, and therefore it has the right to exercise these powers.
Well, I find it very difficult to read that much into Parliament's inaction, bearing in mind that it reassembled on the 3rd of September for a very short period. The only thing that it could have done, I would have thought, was it could have passed a resolution, but the present government and Mrs May's government made it perfectly clear that they did not think that they would necessarily be bound by resolutions short of statutes. They could have passed a statute. I think that what they decided was that in the short time available it was better to concentrate on passing the Ben Act. But I would be very cautious before drawing too many positive conclusions from the mere negative.
If I could add to that, I thought it was rather disingenuous of the government lawyers to suggest that Parliament could have done something about this. I think it would have been very difficult for a number of reasons. I mean, in terms of when it should have done something, we've heard, going back to the slightly longer history, that there was an attempt to amend the Fixed-Term Parliaments Bill when it was going through Parliament, a proposal from Chris Bryant that prorogation ought to be limited. That was resisted by the government for reasons which might be obvious, I suppose, because this is constraint on their powers, and they would always be inclined to resist if they can. Before, in the run-up to this announcement to prorogue, of course it was a very hot topic in the Conservative leadership contest. The chair has already referred to this and his own views on it and the advice that he gave to candidates, and several members of the cabinet had indicated that they didn't think this would be the right way to act, and Boris Johnson himself had said that he was not attracted to it. So you could say that in a sense parliamentarians had been led to believe it wouldn't happen, and therefore when it did happen it was quite a shock. And as Lord Sumption says, there were very few days when Parliament was sitting. I am told that there was discussion among some of the so-called Rebel Alliance on whether to put aside the Ben Bill and have a bill to prevent prorogation. But there were three obvious problems with that. One, they didn't have one ready because they hadn't been expecting this to happen. Two, if they had tried that and it had failed, they would have lost the only opportunity that they had to get the Ben Bill through. And three, which is a rather finer point, it seemed very likely that any bill to limit prorogation, which as Lord Sumption says would be the only way of being sure to be able to constrain it because a resolution might not have been considered enough. If there had been a bill attempting to constrain the prerogative, it would very likely have been judged to engage what's called Queen's consent, and therefore there would have been an executive veto on that bill. So it very likely would have failed, and the opportunity to pass the Ben Bill would have been lost. The only other option they had, of course, was to pass a vote of no confidence in the government in that time and replace it with a government which would have asked for the prorogation to be reversed. But again, you've got a very short time period there, not only to have the vote of no confidence, but to get an alternative government. And if you didn't manage to do it within the time, you would have triggered the Fixed Term Parliament Act period, during which time, with Parliament prorogued, the Prime Minister would have been able to fix a general election date, and there were obviously fears that that general election date could be after the 31st of October. So I think that Parliament's hands really were tied, and I suspect, although I don't know, because this would be the subject of their internal discussions, that this may have been one of the things that influenced the court, because it seemed perfectly clear to me.
I doubt whether it influenced the court, but I agree with every word that Professor Russell says.
Well, moving on, Marcus Fish.
Thanks. Some have said that the issue of ultra vires within the judgment was something that was in effect, because in effect the executive in the UK has never in fact had the authority to prorogue Parliament. Now I understand, Lord Sumption, that you might have a slightly different view. I wonder if you could explain where that opinion comes from and why you might take a different view.
Well, ultra vires is a subject on which the courts have got into a terrible muddle. because they have never been able to make up their mind on any very satisfactory criteria, whether it means that the government or the decision maker simply lacks the power to do it at all, so that the attempt to do it is just a non-event, or whether it's another word for abusing a power that unquestionably does exist. The word ultra vires has been used to describe both things, although they are obviously conceptually completely different. So, without seeking to evade your question, I think that life would be simpler and clearer if we didn't use that particular expression. The decision undoubtedly was that it was unlawful, and that was a decision which was radical in its reasoning, but very conservative in its result. And I agree with what Professor Craig has told you earlier today, that this didn't simply come out of a clear blue sky. The exercise of the royal prerogative by ministers has been reviewable for 25 years, since 1984, the decision in the GCHQ case. The law has always been careful that there are very few, if any, unlimited powers. The classic statement is that of Lord Diplock in a slightly earlier case, where he said that ministers are responsible to the courts for the legality of their decision, and to Parliament alone for their policies and the efficiency with which they carried it out. But the courts have never accepted at any time that ministers can be responsible to absolutely nobody for what they do. And the problem about this prorogation was that it created a period of 5 weeks when there would have been effective responsibility for nobody, and retrospective political sanctions of the kind suggested as appropriate by Professor Ekins would in all probability have come too late.
So what are the implications for our understanding of executive power when it comes to other types of things? We were discussing earlier the idea of the advice to the Queen on who to send for. That is convention. It isn't strictly an executive power, i.e. it is the reserve power of the sovereign, but it clearly is analogous from one point of view. What are the implications? Is anything reviewable?
I don't think that you can assume that the reasoning behind the decision on prorogation can be transposed to that or many other contexts. I mean, prorogation is in some ways a very self-contained and slightly eccentric island of the law. And the reasoning of the Supreme Court is very specifically directed to prorogation. I cannot see the court interfering in the process by which the Queen decides who to send for. And I think that although famously Mr. Macmillan did tender very forthright advice to the Queen about his own successor, I think that the correct view is actually that the Queen is not bound by his advice in circumstances where he's an outgoing minister. But the point that you raise does, I think, raise one very, very significant question, broader question. We have a hereditary head of state. We have no constitutional referee in areas which are not necessarily covered by law, because the Queen, by constitutional convention, is required to accept the advice of her ministers. The result is that the monarch is incapable of performing the function of referee of last resort on constitutional issues, which is performed by nearly every other non-executive head of state in the world. Now, one understands that her very delicate position as a hereditary monarch is the justification for that. But, for example, in the Netherlands, where they also have a hereditary monarchy, the Queen takes an active but not a personal role in the formation of governments by appointing a commissioner whose job it is to negotiate with the various interested parties until a consensus can be found to support a particular government. And I think that it is important that in the longer term that we should devise a system which enables the powers of the monarchy to be exercised, and which frees the monarch from the exclusive dependence on the advice, often self-interested, that ministers give her. My own view about this, which I have expressed earlier, is that the Privy Council is the institutional is the institution through which the royal prerogative is exercised. I think that there should be a constitutional committee of the Privy Council, which would have some lawyers, but a minority of lawyers, which would be charged with giving the monarch independent advice on the constitutional propriety of things she is being asked to do by ministers, especially in areas which really are governed by convention and not by law.
I think, could I just add, I think these are very interesting ideas, but I wanted to come back to your question from a couple of angles. I mean, firstly, I think it was established on the previous panel, and I don't know whether we'll come on and talk more about this later, that on the matter of appointing the Prime Minister, the Queen genuinely does act as a long stop. She does have discretion on that if a Prime Minister has lost the confidence of Parliament. So I don't think the courts are needed as a long stop on that particular thing. With respect to whether we're entering now some kind of free-for-all where all government powers are up for judicial review, etc., I think, as the court said, it's already been referred to, they saw this judgment as a one-off. And I think, as Lord Sumption has referred to prorogation as being, a funny little island, the point was that at the very core of this case was the question of the place where the courts usually ought to kick things that might be seen not as their business, not being available to have the matter kicked to it, because where the courts are usually criticised or can be criticised for meddling in things which are political and not their business are matters on which Parliament, as the sovereign body in our constitution, ought to be deciding. But this was one thing that the courts could not refer to Parliament, because Parliament clearly did not have the power to unprorogue itself. So I think in that respect this is a one-off. It was precisely about the sovereign body in our constitution, the head of the political constitution, being shut down, and therefore the legal bit of the constitution having to step in to resurrect it. So I'm not sure that it is the start of something new. I think it might be, as the court says, a one-off, but having said that, of course, I'm not a court watcher and I'm not a lawyer.
I broadly agree with that.
Can I just ask one or two supplementaries? Presumably, Her Majesty does privately take legal advice. If she thought she was being asked to do something illegal, she would want to have that conversation, albeit privately, with the Prime Minister about it, on the basis of that advice.
I'm not sure that that's so. I do not know from the inside. I would think that the Queen was certainly entitled to ask the Prime Minister to lay before her the view of the Attorney General. But I think there would be serious problems about her taking legal advice outside the framework of government altogether. Okay. And I'm not aware of any occasion when she has sought to do so.
But your mechanism is basically recommending that she should be able to do that from this special constitutional committee of the Privy Council?
Yes, that wouldn't, it wouldn't simply exclusively be legal advice. I would envisage a committee of the Privy Council which would comprise elder statesmen with a minority of legal members.
And secondly, we're discussing, of course, what the sovereign's discretion is in the event that the Prime Minister has tendered his resignation, or her resignation. In the 14-day period, there has been a suggestion that the Prime Minister would not seek to facilitate the handover to an alternative administration, and on the basis of his belief that there would not be a government he could recommend to the sovereign that would actually command confidence. Would the court be minded to intervene in that process if the sitting Prime Minister was seen to be frustrating the handover to a different administration by refusing to resign? Essentially,
I think it shouldn't be seen as the job of the Prime Minister to choose the next Prime Minister. It is essentially, and this is, we may get into talking about minority government later. I think a lot of these things get confused in a context of minority government, which we're not very used to. It is fundamentally the position of Parliament to recommend, if you like, to the Prime Minister to the Queen, who ought to be appointed as an alternative Prime Minister. One of the difficulties with the Fixed Term Parliament Act is that it doesn't set out any specific mechanism for Parliament to do that. And I think, that's another gap which might need to be filled. But I think that the reason for that gap is that under normal circumstances, probably what was envisaged when the Act was written was that you're talking about something like a coalition government where one of the coalition partners decides to depart and join with the official opposition to form an alternative majority. You have reliable voting blocks within the House of Commons. It's fairly clear, therefore, who the Queen ought to be appointing as an alternative Prime Minister. The difficulty in this Parliament, which is bringing all this to the fore, is that it's so fragmented, there's so much division within the major parties and so many little groups and people acting as independents that it's not clear where the majority would come from. But ultimately, I think, in terms of the 14-day period, it is for Parliament to signal in some way, if we get into that situation, to the Queen who ought to be appointed as an alternative, who would enjoy the confidence. And there are various ways that you can imagine doing that. It could be anything from an early day motion, it could even be a letter, it could be a vote on the floor of some kind to request maybe a humble address to request that the Queen appoint a certain person. I think it's a mistake to see it as the Prime Minister's job to say who that should be.
Well, the Cabinet Manual describes it as the Prime Minister's job in order to insulate the sovereign from political controversy, that the Prime Minister must recommend to the sovereign the name of a successor who is likely to command the confidence of the House of Commons. My question is different, which is supposing the Prime Minister just doesn't want to do that because he wants a general election, and so he doesn't resign.
The assumption behind the 14-day provisions of the Fixed Term Parliament Act seems to be that the Prime Minister will resign if it becomes clear that somebody else commands the confidence of the House. The problem about the Act is that the second resolution, that the House does have confidence in Her Majesty's government, assumes that by then there is another government in place in which it has confidence, but without describing how that government is to come into existence. My own view is that the Prime Minister is entitled to squat in number 10 Downing Street until it does become apparent, and a loyal address might be one way of doing it, that there is an alternative government that would command a majority, and that he is then bound to resign. My reason for thinking that is simply that the Fixed Term Parliament Act simply can't work in any other way.
And the court would be likely to enforce that if he squatted?
Well, they would, because a statute is by definition justiciable in all its respects. So the courts would have to decide what those provisions, the 14-day provisions, meant. And they will not simply confine themselves to woodenly reading the language. They will say, in order that this can work, it must have been intended that this or that should happen.
You mentioned the Cabinet Manual. As it happens, I have taken a little fragment from paragraph 2.19 of the Cabinet Manual. Please don't test me on any others. This is the only quotation I've got. But it says, the Prime Minister is expected to resign where it is clear that he or she does not have the confidence of the House of Commons and that an alternative government does have the confidence. So the comment in the Sunday Times this weekend from supposedly a senior Cabinet Minister that there is nothing in the Fixed Term Parliaments Act that says you have to resign, the Queen is not going to fire the Prime Minister, she would dissolve Parliament and let the people decide, I think is a statement in contravention of the Cabinet Manual. I think the Cabinet Manual describes what should happen.
Well, the Cabinet Manual describes what should happen, but it's also correct that there is nothing in law.
Of course, the Cabinet Manual isn't law,
yeah.
but I'm not sure what you would say.
But what Lord Sumption is saying, we might well find that there is a law.
I think it's a correct statement of what the Fixed Term Parliament Act 14-day provisions must mean if they are to be workable at all.
And I'm not sure whether the Queen would be guided by the Cabinet Manual.
Well, the problem really is that I think that the Queen will wish to avoid any kind of intervention at all. It is true that in theory, as Professor Russell rightly says, the Queen does have a discretion in the formation of government. But frankly, I think that in current conditions she would do almost anything to avoid exercising that discretion. Somebody else has got to do it. So we've got to amend the Fixed Term Parliament Act to make it clear how that's going to happen.
Right. We must move on. Ms. Huck.
Dr. Huck.
Dr. Huck.
I have a PhD. But I'm not a professor like everyone else today.
I'm not a professor either.
Good, that makes two of us. The Supreme Court found that the government didn't present any reason, let alone a good reason, for proroguing, for this prolonged prorogation of 5 weeks. So they didn't actually judge whether the government had reasonable justification. So that sort of appears to hint that we might be opening the door at future reasonable justification assessments. Do you think those might become more commonplace?
Well, this, I think, takes one back to the discussion that we had earlier. I think that we do have a problem, because I don't think that one can assume that political prorogations are a thing of the past. What I think we can assume is that because of the Supreme Court judgment, any government that wishes to engage in a political prorogation will put forward a large number of supposedly plausible reasons for doing it. And the court will then have to decide, one, whether those are the true reasons, and two, whether they are a reasonable justification. Now, I have serious misgivings about courts engaging in that exercise, which is why I think this decision should be returned to Parliament by way of a motion in the House of Commons.
Ah, right. And so if this government had the thumping big majority it craves, none of this would apply?
Well, I think it may well happen again. I mean, after all, there have been at least 5 political prorogations in the history of Canada, all but one of which are within the last half century. So, you know, this is not a completely extraordinary event, and I think that we must expect that, not necessarily soon, but sometime we will have to face this problem again. We should be forearmed.
No, I mean, I agree with that. It goes back to what we were saying before about replacing the prorogation power operating as it does now with one that gives the power to Parliament. I mean, I think it is... I don't want to be... Jonathan's maybe being a bit gloomy in saying that these things will happen again, but of course it is the case that once a taboo has been broken, habits can form. The court has squashed this particular prorogation, but if people wanted to start gaming the system in future, playing around with shorter lengths of time and some reasons which might or might not be considered inadequate, maybe they could do so, and it might be better just to knock the whole thing on the head and say that the House of Commons must decide whether it wants to be prorogued as it decides whether it wants to be adjourned or dissolved.
I mean, do you see a possibility of this reasonable justification assessment being performed by courts? You'd rather it was Parliament, but could you foresee that happening?
Well, I think it is undesirable that a decision which in almost all cases is going to be decided on purely political criteria should be made by the courts. I think it's undesirable on objective constitutional grounds, and I think it would undermine the independence of the courts in a way that is undesirable in a much broader sense. I think that Professor Craig was right to say to you an hour or so ago that in exercising this power to decide whether the justification was reasonable, the courts would give a generous margin of discretion to the Prime Minister. But that in itself can be problematical. Suppose that one must expect his generous margin of discretion to be exercised in his own political interest. And suppose that Parliament took a different view. I'm not sure that the answer is to allow the courts to decide something which is as broad as that, because that just aggravates the problem arising from the political nature of the question.
You know, it's worth going back again to say those words, minority government. I mean, you know, these kinds of tensions at times of majority party government or even majority coalition government, if you have a stable coalition, are very unlikely to occur. But, you know, maybe we need to fix some of these things in anticipation of a future minority government or unstable government situation. Most of the time we wouldn't need the provisions, and it would be a pure formality that the House of Commons voted, because it would vote in line with what the government wanted, because the government and the majority in the House of Commons are in agreement with each other.
I mean, I think we may well be heading for a period when there will be more minority governments, more coalition governments, and when the stability that we've taken for granted for many years, up to recently, will disappear.
Yeah, no, all the polls are predicting we might have a government with a third of the vote or even less. Does the reasoning used for justice, the ability, open the possibility of using a prerogative power in a new or extended way that impinges a constitutional principle or some other law, so long as reasonable justification can be provided?
Well, as I've said, and as I think Professor Russell has also said, I think that this judgment doesn't open up that possibility because it's concerned with a specific and a rather special sort of power exercised in a most unusual situation. After all, major changes, political changes such as that which will follow from our departure from the EU, normally happen by positive decision. A lot of the problems in this area have arisen recently because a major change is liable to happen by virtue of nothing happening by the relevant cut-off date. And so there's a premium on inaction. Now, this is a combination of circumstances that I can't imagine arising very often.
And any other safeguards you would recommend, if not?
What, on prorogation? Well, there is Professor Twomey's idea that you can unprorogue yourself by vote of Parliament. I have to say I find that rather clumsy. I think it's much cleaner and neater and administratively easier for Parliament to decide whether it wants to be prorogued or not. Mr. Cowan.
It's interesting that it would appear to be going to a period where there are going to be minority governments and coalitions, and yet this place is completely inadequate at working in that sort of setup. So we're going to have to learn how to work together across party to actually achieve anything, or it's going to be a downward spiral. But looking at the judgment of the Supreme Court, it made it clear that prorogation, in this case 5 out of 8 weeks, leading up to a major constitutional change in leaving the European Union, impinged on the fundamental constitutional principles of Parliament, sovereignty and Parliament accountability. So what are the implications of the weight given by the court to these principles for how we understand the UK's constitutional arrangements?
Well, I have said that at one level this judgment can be seen as a kind of earthquake, but at another level it can be seen as absolutely obvious. I've referred to it as Politics 101, because it's very surprising to see a situation where the courts have had to step in this way, and that the Prime Minister has been found to have acted unlawfully on such a sensitive issue as the advice that he gave to the Queen. And to see the court resurrecting Parliament is a pretty extraordinary thing. But the principles that they advocated, that they articulated in the judgment, were absolutely uncontroversial, central principles. And I say British Politics 101 because they're literally in the first class that I teach my British politics students. That the British Constitution is characterised by parliamentary sovereignty, Parliament being the highest authority, and the fact that the government is accountable to Parliament and ultimately, in extremis, can be removed by Parliament. And what the court did was emphasise those principles as the underpinning reasons for its judgment, and in doing so, I think just stated some very obvious things about the way that the system works, which I hope will help people in future to understand the system better. If there was anything very unusual about what went on here, I think it was the fact that the government acted in the way that it did, requiring the court to respond in the way that it did. I had a look at what some of the other commentators have said, and a lot of them agreed with the sort of thing that I said in terms of this being both extraordinary and mundane. Professor Shona Douglas-Scott from Queen Mary said that it was a remarkable ruling but an orthodox one. Professor Mark Elliott from Cambridge said it was rooted both in orthodoxy and it was path-breaking. And Professor Mike Gordon from Liverpool University suggested, and I think this is a key point, that the ruling may not even be the most significant constitutional event this month. And I think probably what he was referring to there was the actions of the government, but there have been quite a lot of big constitutional things going on, so I'm not quite sure what he had in mind.
The contrary view, which I don't share, but I mention it because I think it comes close to what you're concerned about, is the one expressed by Professor Ekins, which I think can be fairly summarised this way. He says, OK, Parliament is sovereign, and that's a proposition of law. There is no source of law higher than parliamentary legislation. But accountability, he would say, is not a proposition of law, it's a mere political fact. Now, Professor Craig had some very critical words to say about that theory, and I agree with all of them. It seems to me that parliamentary accountability is the whole basis on which the courts draw lines as to what decisions they may interfere with and which decisions they can't. It's also an essential underpinning of the separation of powers, because it enables the courts to distinguish between those matters in respect of which ministers are responsible to the courts and those in which they're responsible to Parliament. I think parliamentary accountability is a very familiar concept in law, and it is simply nonsense to say that it has no existence except as a political fact.
And it was, of course, a factor. I'm not saying that this was a factor in the court's judgment, but I commented, as many of you may have seen, when the prorogation happened, on what was extraordinary about the prorogation, not only that it was the longest prorogation for 90 years, but that it came at a time when the Prime Minister had been in office while Parliament was sitting for only one day, and Parliament had just been subject to a 5-week recess in the run-up to a deadline to make a very serious decision by the end of October. So within this, across the summer, there had been, of course, a lot of debate in the media about the potential of a no-confidence vote in the government. So it seems to me that shutting down Parliament at a time when there was this deadline, and also there was at the very least a question as to whether the government's confidence was going to be maintained, was very problematic. And that was in contravention with the principle of government accountability to Parliament and the fundamental which I referred to, that ultimately Parliament can remove the government from office. So it scrutinises the government, it holds the government to account for its actions, and if it is not satisfied with what the government is doing, ultimately it can remove the government. But it cannot do any of that if it is prorogued.
Mr. Hopkins.
Thank you, Chair. My first question was going to be to Professor Russell. You've anticipated that in your quotes I've got written down here, which is very interesting. So I've gone to your assumption, if I may. In your Reith lectures, you've raised concerns about the expanding empire of law, as you put it, and the decline of politics. To what extent do you think the Supreme Court's judgment on prorogation is a continuation of these trends?
The reason for objecting, as I do, to the extent to which the courts have intervened in what I would classify as political matters, is that it undermines the legitimacy of democratic decision-making. This judgment, I don't think, does have that effect. There is a world of difference between the courts arrogating to themselves a power which politically ought to belong to ministers responsible to Parliament, on the one hand, and the courts simply saying, as they have done in their recent decision, this is a matter on which Parliament must be enabled to make decisions. The difference is fundamental.
Just talking about the Fixed Term Parliament Act, I mean, it occurs to me very simply, if you want Parliament to make a decision, we could have had a general election had there not been the two-thirds majority required from the House. I mean, if the government had said we wanted it, 50% plus one, we would have had a general election. Isn't it, in the end, handing the power back to the people to make a decision in a general election? That would be the solution, surely.
Well, the problem
one too.
was correctly identified, I think, by Professor Craig when he considered this area, which is that in principle, to hand to the executive an unfettered discretion as to the timing of an election so that they can use it to their own electoral advantage, gives them a weapon which can be used manipulatively, and historically quite often has been used manipulatively, to get a popular endorsement which they wouldn't necessarily have got at any other time. So the principle of the Fixed Term Parliament Act seems to me to be wholly acceptable. What is problematical about it is the detailed mechanics, and in particular the mechanics of the 14-day period of grace, which has not been properly thought through and has had the ironic effect of allowing ministers to stay in power longer than they would have done under the previous system.
And I think, again, the deadline, the looming deadline at the end of October is absolutely crucial here. I mean, it was relevant to the difficulties of the timing of the prorogation, and I suggested earlier in the summer, even of the recess, given the need to scrutinise the negotiations and scrutinise the no-deal planning and so on. But it has also got tangled up with the operation of the Fixed Term Parliament Act, I think, where perhaps if the deadline had not been hanging over us, perhaps the House of Commons would have voted for a general election. But there's this fear of wasting time between now and the deadline and potentially having a general election period which even spans the deadline. So I think that we're in a very peculiar period of politics here, where we have the decision of the referendum hanging over us, we have the deadline, we have minority government, and this is creating a very kind of unhappy, almost purgatorial situation where we need to get beyond the 31st of October and do our best to put politics back on its feet, I think.
Mr. Finch.
Do you think that this arguable entry into the world of politics, in one sense of this judgment, means that it will extend into reviewing the government's ability to make treaties?
No. Governments, I don't think that anybody is going to limit the government's power to make treaties any more than they are already limited. The government cannot, by making treaties, alter the law of England or of the United Kingdom.
Glad you slipped that in.
Yes, I'm sorry about that. It needs a statute to do that, so Parliament does get a look in there. The only areas where the government can make treaties free of parliamentary interference is where the treaty has no impact on the internal law of the United Kingdom. For example, a pure treaty of political alliance. Even in that context, there is, of course, a convention which has always been observed since the 1920s, when it was first formulated, the Ponsonby Convention, under which treaties are laid before ratification, before both houses of Parliament.
Yeah, I was one of the intriguing things about the judgment was that it was supported 11-0, in my view. And as a layperson, reading the judgment, it seemed to me to be highly unlikely that, given some of the language in it, which was arguably kind of straying into the florid at times, words like extreme would seem to me, in the context of the extreme effect on the fundamentals of our democracy, to have potentially been a point of contention, and I would be extremely surprised if 11 incredibly distinguished jurists would have agreed on such language. I'm just interested in your view as to how it could possibly have come about that 11 such people could have agreed to use such language.
Well, I sat in the Supreme Court for 7 years, and I have to say that the court includes a large number of people whose arms are very untwistable. Yeah. So I do not buy the theory, which I've heard from many quarters, that there must have been some draconian manipulation or some command that people should jolly well get into line. I suspect that the reason why they steer well clear of the question what the government's reasons really were and whether they were reasonably justifiable, is that if they had entered upon that territory, there would not have been unanimity. I mean, it seems to me perfectly legitimate for a court to avoid an issue on which they are not agreed in order to decide the case on a ground on which they are. And I think that's probably what happened. I have no inside knowledge, I should say.
Could I just add something related quickly?
If it's quick.
Yeah. I just wondered what you made of the Attorney General's suggestion in the statement last week that we should replace these Supreme Court judges with a more American-style political appointee version.
That suggestion assumes...
Nicking somebody else's question.
Oh, no. I didn't think it was on there. No? I
Anyway, you
haven't
better
seen it
answer
on
the
there,
question.
that's why I added it. Okay, sorry.
That suggestion assumes that the political views of judges influence their decisions on questions like this. In a confirmation hearing, how would you satisfy yourself that you were going to get judges that were or weren't going to reach the sort of conclusion that the Supreme Court did in this case? Would you ask them whether they believed in Brexit or whether they were Remainers? I mean, it is, to my mind, confirmation hearings are constitutionally inappropriate because they undermine the judiciary by associating them with political positions, and two, useless, as they have been for many years in the United States, where ever since Robert Bork's confirmation hearings in the late 70s, there's been a perfect routine for these confirmation hearings. Whenever you're asked as a candidate whether you would, how you would decide a particular case, you say, I would have to listen to all the submissions of either side before coming to a view, so I decline to say. And that's the right answer, and it's an answer which leads nowhere.
A better solution is to make sure that the judges aren't compelled to take political decisions.
I think that's true.
Some of the American ones turned out to be unexpectedly liberal when they were appointed as Conservatives.
Oh, yes. The moment you let judges out of your sight, they engage in untutored thinking.
David Jones.
Yes, Lord Sumption, after the Supreme Court judgment, you wrote an article in the Times in which you said that political conventions are a better, more flexible and more democratic alternative to law. But if we are to avoid a wholly legal constitution, we must honour them. And then you referred later in the article to what you described as the constitutional vandalism of the Prime Minister, and went on to say that the natural result of that was that conventions have hardened into law. That's the effect of the Supreme Court's decision. And you went on to say that that was very regrettable.
Yes.
Do you believe that this judgment has generally protected or will act as a protection to conventions in the future?
Well, I hope so, because I hope that ministers and others will learn that if they deliberately play fast and loose with conventions on which our system is founded, they will end up with a much harder set of rules, which I think would be very unfortunate. They would be less flexible, they would involve more judicial intervention, and I think it is 1,000 pities that the government put itself in a position where the Supreme Court had to do what it did.
And this lack of flexibility is why you refer to the outcome of the judgment as being infinitely regrettable, I take.
Yes. I mean, legal rules tend to be rules which shut stable doors after the horse has bolted. And they then have to be applied to all the jumpy horses that are in the stables next door, with results that are often very unpredictable. I think that it's a less satisfactory way of dealing with these matters. I mean, our Constitution, as Walter Bagehot said 150 years ago, is famously flexible. That has been a tremendous advantage. It has enabled this country to retain the basic constitutional same basic constitutional framework for 300 years of very radical change. There is no other constitution in the world, even the Constitution of the United States, that has survived unchanged in its essential respects, because capable of adapting to new challenges to quite the degree that the British Constitution has. And I think that is something that we should welcome and value.
What more can be done to protect conventions, or do you think anything further needs to be done? Do you just hope that the government will learn from this experience?
It's a question of shared political culture. If you destroy the shared political culture, then nothing can be done. And I very much hope that one lesson that people will learn from this is that they should respect the political culture. The ends do not always justify the means.
I think it's very, very difficult. I mean, our system clearly rests more on convention than many other systems do, and that requires people to respect the conventions and use the flexibility where it's appropriate, but not to abuse the conventions and the traditions, and not to see the law as the only constraint upon them. But all constitutions depend to some degree on convention, and they all depend on people behaving reasonably and respecting the rules and traditions. I mean, if you go back to the point that we were talking about before, about the potential of a Prime Minister refusing to leave Downing Street if an alternative Prime Minister could command the confidence of the House of Commons, I mean, that's not a problem which comes just from the conventional nature of our Constitution. It's tantamount to a President of the United States refusing to leave the White House if an alternative president had been elected. And I think it's equally difficult to deal with in both systems. I mean, if you take it down to the level of ordinary people, it's like having an eviction notice served on you and refusing to leave your house. And if you get to the stage where you're needing bailiffs and policemen and the National Guard to remove people, you have a society or you have a political system which basically is not functioning. We cannot function in that way.
But if you're going to have a system where Parliament can impose laws on the government that are contrary to its policy, all sorts of things are going to go wrong. In the United States, the President has a veto power.
Yeah.
This is not how our separation of powers operates, because it assumes that the government controls Parliament.
I think this takes us back, though, to the point of minority government. I mean, it is the politics 101 that I referred to before, which I think has been reinforced by the court case, is that the senior partner in the British system is Parliament, not government. The government only is the government because it has the confidence of Parliament, and it relies on Parliament to get its legislation through. So if Parliament legislates contrary to the will of the government, that in itself is not a revolutionary act.
But what would you do? Except if I may, what do you do where you have a House of Commons that will wound but not kill? Because in reality we know that this government doesn't really enjoy much confidence from this House of Commons, but they haven't got the guts to deal with it.
Well, that's the purgatory that I was referring to, and I think the answer ultimately is get beyond the 31st of October, because we are in this peculiar, unique situation.
But my other point is that the very legitimacy of Parliament is undermined if you have a Speaker who is not acting by convention and is not honouring the conventions that are there within our Constitution. It's a fundamental of our Constitution that the Speaker is unbiased, and that is arguably not the case in this instance, and that is affecting Parliament. But so do you think, for example, that it is time to review the Bill of Rights to see whether proceedings of Parliament in certain circumstances can be reviewable by the Supreme Court, just as it is the last bulwark against abuses of other parts of our Convention? How can that not be a valid area for review as well?
No, I don't. And on the Speaker, I would say that obviously we're in very, very delicate water here. There's lots of controversy going on. But the Speaker, I think, he would see himself as trying to facilitate the majority in Parliament, and the Speaker is subject to a very similar mechanism to the Prime Minister. If the House of Commons doesn't have confidence in the Speaker, it can remove him. That is his accountability.
Also, it didn't have to to vote to take away the government's control of the order paper, as it did in May and again in September. There was a parliamentary majority for that.
But only by reinterpreting standing orders.
Well, I think that the interpretation of SO 24 was very questionable. But the earlier ruling allowing MPs to take control of the order paper was based not on a standing order, but on precedent. And there, I think that the practice of Parliament must depend on what Parliament does.
There was no precedent of
the precedent was that you could not amend the business motion. So the precedent was wholly in favour of the government, and it is perfectly true that the Speaker, with the support of a majority of Parliament, departed from that precedent. Well, I find it hard to believe that any practice of Parliament can be like the laws of the Medes and Persians and incapable of alteration even with the consent of a majority of Parliament. I certainly think that in the case of SO 24, it may well be that the proper approach would have been to amend the SO rather than simply to drive a coach and horses through it. But that's not a problem that arose in May.
The words of Humpty Dumpty come to mind.
It's something you said, talking the opposition parties not having the guts to deal with this. I would interpret that as not being prepared to walk into a giant elephant trap. When the time is right, we will deal with this government.
I accept that. But the House of Commons did have the option of having a general election before the 31st of October.
Yeah,
but you need to disentangle these issues.
That's the elephant trap we're talking about.
Yeah.
That's why you can walk out of the EU with no deal.
No, if the election had taken place, well, I'm not looking for it. But anyway, Dame Sherrill.
The gist of most of my questions, just in this section, have really been taken by colleagues. So I just wanted to ask you, do you really think that that opening statement from the court is true, that this is going to be a one-off decision of the Supreme Court? And do you think that when the Supreme Court was put in position, that this activity was envisaged to fall within its ambit?
Well, if I may answer the first of your questions, I don't think one can count on this being a one-off, because even in the context of prorogation, there's too much of a history of it in other jurisdictions for one to be able to say that. As to the status of the Supreme Court, I think there's a lot of misconception about this. The Supreme Court is simply the Judicial Committee of the House of Lords under another name and in another place and with a much larger budget. That's the only change. The powers are the same, the procedures are the same, the habits of thought are the same. There is nothing that the Supreme Court has done which the Judicial Committee wouldn't have done before 2009.
I'm inclined to think this almost is a one-off. And I mean, in terms of the claiming that we're any claims that we're moving to a situation where we're ruled by judges rather than ruled by Parliament, I think is quite wrong. I mean, our Constitution, retains its unique character that we do not have a written document which has a status above ordinary law, that Parliament can make or unmake laws. The point in this case was simply that, and in those cases, the judges adjudicate, and the legislature is weaker. We do not have that system. We have a system where Parliament remains sovereign, but Parliament cannot act if Parliament has been prorogued. And I think that is the unique nature of this case. It may not be entirely unique if, as Lord Sumption suggests, we have other arguments about prorogation, and the way to prevent that is to solve prorogation, as we referred to before, by handing that power to Parliament.
I sit on the Council of Europe for the UK, and of course have the responsibility of voting for the judges there. And Lord Sumption, you raised concerns about the role of the European Court of Human Rights, because it was inventing, in your view, additional rights that are really quite contentious and far from being fundamental. But do you see that any of the factors that we have developing in our own legal system here might lead to a UK court making decisions that have that consequence of inventing rights and laws?
Well, there is, as I've said, a very radical difference between the courts intervening to preserve the powers and autonomy of Parliament, and the courts intervening to decide for itself matters that, on a traditional view, should be decided by ministers answerable to Parliament. But I think that your question is really getting at, are there signs that the UK courts may be taking over the mission creep which has affected the Strasbourg court for the last 30 or 40 years? To which my answer is yes, there are not only signs of that, but it has in fact been doing so for a good 2.5 decades, if not longer. I explained in my Reith lectures why I thought that that was not consistent with a democratic constitution, save in respect of a very limited class of core rights, certainly a much more limited class than the British courts and the Strasbourg court have classified as justiciable rights.
Thank you.
So I share your concern.
So to what extent is sovereignty of Parliament now justiciable?
Well, that is a hotly debated question. My own view is that the sovereignty of Parliament is not justiciable, it's not up for grabs. There are people who have suggested otherwise, judges, both in judgments and in extrajudicial statements. Personally, I deplore that. It seems to me that in an unwritten constitution we have only one sheet anchor, and that is the sovereignty of Parliament. If you depart from that, you create what amounts to an unamendable constitution which is wholly outside the control of anybody responsible ultimately to the electorate. I do not think that can possibly be justified. I think that on this, the late Tom Bingham got it absolutely right in his book on the rule of law, and I deplore suggestions to the opposite effect.
And by the sovereignty of Parliament, you mean in the Dycean sense that Parliament has the power to make or unmake any law?
Exactly.
Yeah.
And indeed, that proposition was clearly reaffirmed in Miller No. 1, and reaffirmed by reference to the statement of Dicey itself.
Just a stray spider, they're all the rage these days, the spider letters case, which seemed to overturn the, in the Evans case, seemed to overturn the provision of the Freedom of Information Act that explicitly allowed the Attorney General to apply an exemption to the Freedom of Information Act, which the court appeared to overturn.
Yes.
Wasn't that the court overturning statute?
Yes, I discussed this case in one of my Reith lectures. In my view, it was a wholly impermissible act, but it depended on the interpretation of the relevant statute. But the Freedom of Information Act on this point, it's not clear on all points, but on this point it seemed to me to be abundantly clear. And I fear that the Supreme Court, and indeed the Court of Appeal before it, essentially took the view that they did because they disapproved of what Parliament had unquestionably done.
And what should we do about
that? One solution, I suppose, would be to reinstate the thing in language which was even more emphatic. But ultimately, if judges are not prepared to respect the meaning of Acts of Parliament, there is very little that can be done about it. I very much hope that such a thing does not happen again. The courts have traditionally been super sensitive about any attempt to control the exercise of their own powers or displace their power of intervention. I think the courts ought to get used to the idea that there are some issues on which a minister answerable to Parliament may be a better judge of the public interest than a judge.
Is it a small step towards the consideration of electing judges as we do in Strasbourg?
Well, the Strasbourg system is essentially a vetting system rather than, the judge is nominated by the home government and the council on which you sit decides whether they're suitable. It has to be said that some of them have been remarkably unsuitable over the years.
Well, there are 47
Not, I have
countries.
to say, from this jurisdiction.
Do you see it as a small step towards a more American style system?
Well, I hope not. I mean, the problem is that there is no European or Council of Europe system for nominating judges. It depends on the practice in the various member states of the Council of Europe. I mean, the starting point in this country, by comparison, is very different. We now have a non-political commission which nominates judges after taking extensive consultations, not from ministers. And so we start from a situation where the factors that make it necessary for the Council of Europe to have a vetting committee just don't exist.
But if the courts continue down that path, it starts to get more tempting.
Well, I mean, I can see that you could extrapolate the practice of the Council of Europe and apply it in England. I hope that won't happen, and I don't think that the fact that the Council of Europe does it in rather different circumstances is likely to make it more likely here.
I would love to do an inquiry into how judges are appointed, but I fear that might extend beyond the immediate remit of this committee. So we will draw stumps there. But can I thank you both very, very much indeed for a very, very interesting session. Order, order.
The proceeding has ended. 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 The proceeding has ended.